Computer. Okay, assalamu alaikum everyone. Welcome. I'll pass it on to Professor Mohamad Abdalla to start his session. Thank you.
All right, Bismillah, Alhamdulillah, wassalatu wassalamu ala Rasulillah, amma ba'd. Assalamu alaikum wa rahmatullah, and good morning to one and all. Thank you so much for joining us. I'm always encouraged and inspired by a hadith, a saying of the Prophet Muhammad sallallahu alaihi wasallam, peace be upon him, لا يشكر الله من لا يشكر الناس. Whosoever does not thank people does not thank God or Allah. So thank you so much for being here today, for your time. I know you're so busy, but you've made some time to listen to this topic. What the heck is Sharia? So I hope you like the title, right? What the heck is Sharia? Now, this is going to be a very introductory lecture or seminar or presentation. And so many of you may already know the substance of this lecture, but if you do, consider this a refresher course, a revision. If you find benefit in this, in the content, then alhamdulillah. So what are we going to cover? As we have advertised, I'm going to talk about what does Sharia mean and what does it cover, or what is the scope of Sharia, and perhaps briefly on what is the difference between Sharia and fiqh or jurisprudence, and what are Sharia's major objectives, the classical major objectives which were outlined by classical scholars, but some of the major objectives which have been outlined and proposed by some contemporary scholars. And also the perhaps contentious question of to what extent can Sharia be practiced in Australia. Now, as we all know, or many of us, the Islam generally, but Sharia particularly, conjures fear in the Western psyche. When you speak, I often say when I give lectures, when you mention the S word, people collapse. You know, so Sharia does have a host of stereotypes and misunderstandings. And I must admit, in the West generally, there is this concern about Sharia, but also among Muslims, there is, to some extent, a misunderstanding of what Sharia actually is. And as Noah Fieldman said, that no legal system has ever had worse press than perhaps the Islamic legal system with Sharia. And anyone who has been in Australia for a while may recall the then Treasurer or Federal Treasurer Peter Costello in 2006 in a speech that he gave at the Sydney Institute, where he said there is or there was no place for Sharia law in Australia, in secular societies like Australia. Because being an Australian means that you do have to believe in democracy, the rule of law, and the rights and liberties of others. Now, as you can see from this statement, that essentially what he was also saying is that Sharia does not believe in these things, that Sharia does not believe in democracy, Sharia does not believe in the rule of law, Sharia does not advocate rights and liberties of others, which of course is not true. But sadly, this sentiment has been repeated again and again. And if it was just repeated by some journalist, then you may sort of let it go. But then when it's repeated by some of our highest officials, then you know there is a problem. Again, in March 2012, the Attorney General for Australia, the Honorable Nicola Roxon, said that there is no place for Sharia law in the Australian society, and the government strongly rejects any proposal for its introduction. And you must have heard people like Pauline Hanson and Jackie Lambie and others say similar, in fact, sometimes much worse statements of Sharia. And not going to indulge in trying to debunk what they have said or what they have not said. This is something for another time, inshallah. But let's start with definitions. So like all things, it's important to understand what we mean by terms and concepts that we are discussing. And so Muslim scholars, the ulama, when they speak about Sharia, they often say there is an istilahi meaning, there is a a lexical meaning, and there is a fiqhi meaning or a technical meaning. And so if we think lexically or linguistically, simply put, Sharia means a path. And any Arabs who are with us today, if you can relate it to the word Shari', which simply means street or road. And Sharia and Shari' mean essentially the same thing, and that is it's a path, it's a road. And I put this image specifically to point out that it is understood among legal scholars that it's a path to a watering place. So in the desert, if they would refer to a path that leads to a well as a Sharia or a Shari' or a path. But taking that lexical meaning into consideration, scholars, many classical scholars and contemporary scholars, they said metaphysically, therefore, it is a path that leads to salvation in the hereafter. So, for example, if finding drinking water will save the life of somebody who is desperate for water, equally, Sharia in its totality and its comprehensive meaning would lead a seeker to salvation in the hereafter. As water gives life to the physical body, Sharia gives life to the soul and the heart, providing ultimate salvation in the hereafter. So that is how a Muslim would understand Sharia. And technically, however, Sharia refers to a body of explicit revealed laws known as nusus, which is the plural of nas. We could understand it as definitive, explicit laws, and that'll become clearer as we go, which are found in the primary sources of the Quran and the Sunnah. Sunnah, we could also interchange the word hadith with Sunnah, the sayings, the actions, and the tacit approval of the Prophet Muhammad, sallallahu alaihi wasallam, peace be upon him. Now, these nusus, or these explicit, definitive, textual evidence that one finds in the Quran or the Sunnah, provide the subject matter of the law, or the subject matter of Sharia generally. So, as an example, the nas, or the explicit text, is known to be fixed and unchangeable and largely general. So, for example, a nas that you would find in the primary source of the Quran is wa aqimus salah, establish salah. Now, scholars would look at that from a Sharia perspective or a jurisprudential perspective and say that is a nas qat'i, that is an explicit, definitive law or principle or teaching, wa aqimus salah, establish salah, which is not open for interpretation. It'll be very difficult to interpret establish salah other than what is understood by Muslims, and that is to do the regular, the 5-time ritual prayers. And that is why there is consensus among Muslim scholars that establish salah means establish salah according to the way understood by Muslims as demonstrated by the Prophet. Or, for example, the very explicit nas in the Quran, and do not approach prayer or salah whilst intoxicated. These are seen as explicit, and they are not changeable, and they are fixed to a large extent. They do change when we come and look at fiqh or jurisprudence. The application of those depends on time and place and individual circumstance, and that'll become clearer as we go, hopefully. Now, what is important to understand is Sharia, which is often translated in Western newspapers or as understood by many people. Often it is translated as Sharia equals Islamic law. And that is wrong. That is not correct. Well, not entirely correct anyway. Sharia is more than law. And in fact, Sharia is it's comprehensive of every aspect of life. So it is law. Part of Sharia deals with law, and there are two aspects of that law, and which I will talk about in more details later. That is the personal status law, or ahkam shakhsiyya. But also there is law that is particularly related to government or the executive power of a particular country. Government related or policy related government policy laws known as ahkam sultaniyya. But also, but in addition, Sharia is more than just that. And that's why often in the mind of a Westerner, Sharia is so rigid and inflexible because they see it as law only. And they confine their understanding of Sharia to some textual nusus or textual evidence found in the Quran or the Sunnah, failing to understand the science of Sharia, which is fiqh, jurisprudence, and which I will cover in a second. Now, ethics is part of Sharia, morality is part of Sharia, spirituality is covered by Sharia, and so is metaphysics. All of these aspects are covered in what we know as Sharia. So a Muslim who speaks of Sharia, or I guess a versed Muslim who understands Sharia would understand it to be a comprehensive set of principles or guidelines or laws or stipulations or commands or prohibitions that govern the entirety of a Muslim's life. And that is why the best translation perhaps of the word deen is not religion, but a way of life that is covered by these aspects. So just to give you an example as to the difference between a law and a moral act or a moral stipulation. Take, for example, backbiting, ghiba. Now, Sharia considers backbiting a major sin, but does not stipulate a legal penalty for it. If you go to the nusus, to the textual evidence in the Quran or the Sunnah or the Hadith, you'll find ample evidence to denounce and prohibit backbiting. Backbiting, when the Prophet defined it, he said to speak about somebody behind their back in ways that they don't like to hear it if they were in your presence. Even if what you said is true about them, but it's something that they would dislike to hear if you were mentioned it in their presence. So they said, "O Messenger of Allah, what if what we say about them is true?" He said, if what you say about them is true behind their back, it is backbiting. But if what you say about them behind their back is not true, it is slander. So in either case, you're not safe. But you will never find in Sharia that says a person who backbites should be imprisoned for 2 months or 6 months or should do such and such. Nothing, none of that. Why? Because backbiting does not necessarily have an immediate physical or societal damage. It does have a metaphysical aspect to it. And that is why the Prophet said to one of his wives when she did backbiting, he said, "You have uttered a word that if it was mixed with the water of the ocean, it would change its taste and color and odor or smell." It's a heinous crime, but there is no penalty for it, right? Defamation, on the other hand, is a major sin, which is somewhat aligned to or linked with backbiting, but has a legal penalty. Why? Because defamation has an immediate consequence on the person himself or herself that is often related to reputation. And Sharia is very cognizant and very aware of the fact that people's reputation must be protected. And if this defamation is going to cause serious damage to one's reputation, whether moral or physical or whatever aspect of their reputation, then Sharia says there are certain penalties. And the same, you could say the same thing in the same thing under the common law. You'll find the similar examples. So we could say Sharia provides guidelines for things to do on divorce, marriage, diet, inheritance, prohibitions, business dealings, and so forth. And just to give an example, if we look at the example of a marriage gift or mahr, the Sharia says that a man should, and in fact must, give a woman a marriage gift known as mahar, and not as, you know, the Orientalists would tell us this is to buy the woman. That's nonsense. It's got nothing to do with buying a woman. It is her right to have this marriage gift. And there is a whole discussion about that, which we don't have time to speak about here. So based on the Quran and the Hadith and the consensus of the scholarly community, it is a man who must give a marriage gift or a mahar, based on the Quran that says, and give women their bridal gift upon marriage. Though if they are happy to give some of it for you, willingly and voluntarily, you may enjoy it with a clear conscience, right? But you must give the mahar, and it is up to her to do with it what she wants. It's not up to the father or the mother, it is up to her. Now, whilst the Sharia stipulates a mahar, interestingly, it does not stipulate the type or the amount. Why? Because the Sharia is cognizant of time and place, and it needs to be flexible. And one fundamental rationale, or one of the kulliyat, or the legal maxims that scholars would use when deriving a legal ruling, is the legal maxim of al-'ada muhakkama. Culture is authoritative. Meaning, which is fantastic. You take culture into account and into context when you are trying to apply and implement Sharia, or when you are trying to live your Islam. And in doing so, historically, what Islam did is recognize that that culture is positive and not negative. Though certain aspects of certain cultures may contradict with Islam, and therefore may be deemed negative, but the overwhelming attitude of Muslim scholars was that culture, any culture, is positive, based on the legal maxim, al-'ada muhakkama. Culture is authoritative. That is why I have often said, and if you examine historically the rise of Islam and look at it objectively, although we have had some, you know, some periods where things were not as glamorous as we would want them to be, and they were negative experiences, but by and large, Islam not only protected the cultures in which it went into, but helped enhance it. Unlike the colonial experience, where when they went into cultures such as Australia and came across indigenous cultures, they deemed them immediately as negative and deficit, and they did not see them in a positive light. And so the Sharia says you have to give the mahar, but we can't tell you how much and what type, because that depends on the place and the location. So supposedly, if the Sharia said you must give a camel as a dowry to your wife, well, then many people would be in trouble. In Australia, we might say, well, I want to give a kangaroo or a koala, right? But no, it says it's left. And the other aspect is that a rich person must give according to how much he has. He must be generous and kind, and must not be stingy. And somebody whose financial situation is constrained should also give accordingly. So there is that flexibility. But Sharia talks about morality, and there is a huge emphasis. In fact, what the ulama said is that if you look at the Quran, which is the primary text of all things Islamic, including the Sharia, with its 6,600 plus verses, there are only about anything between 250 to 350 or 60 verses in the Quran that deals with legal issues. That's it. Out of the 6,000 plus, you're talking about anything between 250 to 300, 350 verses which talk about legal issues. And the rest talks about morality, about ethics, about metaphysics. In fact, when the scholars looked at the Quran, they said the Quran could be divided into three portions or three major themes, not in chronological order, but thematically. A third of the Quran deals with the oneness of Allah, Tawheed, who Allah is and who Allah is not. And that is why Surah Qul Huwa Allahu Ahad, the Prophet, peace be upon him, said, he said it equals a third of the Quran, because it's about Tawheed. And then the other third of the Quran deals with morals and ethics and akhlaq, how to become a better human being. And then there's another third that deals with metaphysical reality, the history of nations, to gain lessons so that how to become better human beings. Take, for example, the Quranic narrative, the Quranic verse, those who control their rage or their anger and pardon other people, Allah loves the good doers or the good doers. Now, this is part of Sharia. Sharia says it is necessary to be able to control your anger. And that is why there is a whole discipline in Islam known as tazkiyah, tazkiyat al-nufus or matharat al-qulub, the purification of the soul, the purification of the spirit or the soul or the self. Why? Because one who knows the law by heart, but whose soul is not refined and rectified, will not uphold the law in most cases. Or if they do uphold it, they uphold it only in circumstances where they fear they will be caught if they break the law. And Sharia wants us to move away from this legal, or from being legally centric to more morally ethical centric. And that is, I will abide by the dictates of Sharia regardless of who is watching or who's not watching, because fundamentally I'm inspired by the ethical, moral dimension more than the legal dimension. Sharia on character. There is a beautiful hadith where the Prophet, peace be upon him, said, all of you, many of you are familiar with this, the believers with the most perfect iman belief are those are those who are best in character. And those who are best in character are those who are best to their wife or their family, right? So he defined iman with character and defined the excellence of character to be manifested actually inside the house. When you are with your spouse who knows all your faults, and she knows your faults and you know her faults, and this is where the best manifestation of iman and character comes in. Again, the Sharia does not stipulate any legalities behind this, that, you know, but it encourages us to do so. I see the question from Suhaiba, which will come back to some of the fear people have when Sharia, the idea is punitive punishment. Yeah, we'll come to that, inshallah. All right. So essentially, Sharia is very comprehensive. It is not about law only, but it's about every aspect of a Muslim's life, really. And I say a Muslim's life because Sharia is not and cannot be imposed on a non-Muslim. The non-Muslim or a person who does not identify as a Muslim does not recognize Sharia or does not recognize Allah or His Messenger. And so Muslim scholars understand that you know, we cannot impose Sharia on them, nor are they supposed to follow Sharia. In fact, to the contrary, what Islamic civilization has managed to do in the past, and Muslim scholars have recognized, that is the plurality of legal systems, especially for the people of the Kitab, Ahlul Kitab, or the people of the scriptures, in this case, the Christians and the Jews. But with the expansion of Islamic civilization, the classical Muslim scholars even looked at people like the Sabians or Zoroastrians as people of the Kitab, people of the scriptures. In fact, some classical Muslim scholars also looked at Hinduism or as being at one stage or one period in the history of time being revealed from Allah, or the principles of it having been revealed. And that is why Muslims in India treated Hinduism and the Hindus as also people of scriptures. And in doing so, what Sharia recognizes, and indeed Islamic civilization in the past, it allowed the people of the scriptures to follow their own laws within a Muslim majority context, right? In doing so, I would argue they were far more advanced than many Western democracies in recognizing or in thinking of legal pluralism. Now, often there is a misunderstanding between Sharia and fiqh, and simply put, fiqh or jurisprudence is the science of understanding Sharia. So this picture tells it all. Now you see the well and the bucket. If Sharia is the well, it's the source, the water in this well is what you want to extract. So the source, the Quran and the Hadith, in which we find the text, that is the well. It is the well which has the information. But how do you extract that information? And how do you understand it? How do you apply it based on time and context and circumstance? That is the bucket. So the bucket that is lowered to extract the water is fiqh, is jurisprudence. And it's interesting, I came across this analogy, believe it or not, from a 10 or 11-year-old student in one of my applied Islam classes in Brisbane. After I explained to them what Sharia was and what jurisprudence was, he then said to me, he said, would it be therefore correct to say that if Sharia is the well, then fiqh is the bucket that we use to extract that knowledge? I said to him, you know what? I have never read or heard anyone put it more beautifully than what you have done. And since then, I have been borrowing that. And so fiqh is the understanding of Sharia. And with the exception of the explicit text in the Quran and the Hadith that we mentioned, Sharia generally is not static. Fiqh is not static. It's not immutable. It is not unchangeable, but it evolves in response to changing social, political, economic, intellectual, and other circumstances. Can you recommend some further reading about Tazkiyah? Yeah, we can do that at the end, inshallah. Just remind me. Now, so when Muslim scholars, and when I say scholars, I'm talking about experts in Islamic law or experts in Sharia, when they want to derive or understand or interpret an aspect of Sharia, and not only legal, but any aspect of Sharia, equipped with the science of jurisprudence. We don't have time to talk about the science and the usul of fiqh or the science and the principles of jurisprudence, but they take into account a number of important dimensions, including the maqasid or the higher objectives. But they also take into account the legal maxims or kulliyat, and we don't have time to talk about that today. But we just quickly go through, let's quickly go through the maqasid of Sharia. So in developing the legal system or deriving legal rulings, scholars take into account the higher objectives of Sharia known as maqasid al-Sharia. Imam Ghazali, who died in 1111, and Imam al-Shatibi, who died in 1388, said that if we were to sum up the entirety of Sharia, or the rationale or the reasons for why we have been given by God Almighty a divine pathway known as the Sharia, then it would be fundamentally to preserve or protect 5 essentials. And these are 5 for any human being, not just Muslims: the preservation of religion or deen, preservation of human life, progeny, material wealth, and human reason or intellect. So they said this is what Sharia is about. And you could think of this if in terms of a beautiful principle that Muslim scholars have coined, and which says about God, about Allah, لا تنفعه الطاعة ولا تضره المعصية, that acts of obedience do not benefit God and acts of disobedience do not harm him. So therefore the question is that begs itself, then why does he ask us to do certain things and not to do other things? The answer from an Islamic perspective or Islamic worldview is this: it is for the preservation and protection of religion, human life, progeny. So when Sharia says that intoxications or anything that befogs the mind or anything that makes a human lose control of their intellectual capacity or their physical being through drugs, illicit drugs, or intoxication, it is prohibited. Why? Not because that harms or benefits God in any way, no, but because in the prohibition of these things, there is preservation and protection of human life, but also there is protection and preservation and protection of one's religion or one's progeny, one's wealth, and human reason, intellect. And they also said, interestingly, to preserve the higher objectives. In order to preserve those 5 things that we mentioned, by necessity, it should also preserve essential and other interests by preserving their existence and protecting them from annihilation. To give you an example, so one of the higher objectives says life must be preserved. All right, then it says in order to guarantee that life is preserved, then that which leads to its preservation must be protected. And in this case, the pursuit of medicine or science, but also the establishment of hospitals and medical institutions. And that is why one of the branches of science which Muslims excelled at most for almost 1,000 years was the science of medicine. And the novelty of Islam's contribution to medicine is that it made it scientific, but also created and established hospitals and institutions, and also, and we could debate and argue about this, the scientific method in itself, for the ultimate reason or purpose of preservation of life and preservation of intellect, not for monetary gain. And in doing so, there is a fundamental dialectic difference between, let's say, modern or neoliberal understanding of why we need to have institutions and Islamic understanding of why we need to have institutions. Again, that's a different discussion. To give you an example, if you look at the modern cloning techniques, so the question is, if you would to ask, does Sharia allow cloning? Or is there evidence in Sharia that cloning is permitted or prohibited? And the immediate answer would be, well, if we go back to the primary text of the Quran and the Hadith and the consensus of classical scholars, then we will find nothing on cloning. The fact that we find nothing in these primary texts on cloning, does it mean therefore we should ignore it and deem it unlawful? And of course, scholars would jump in and say, well, no, this is where jurisprudence comes in, the science of Sharia. And it says, using all the legal, philosophical, logical tools at our disposition, at our possession, we have to go back to the Quran and the texts of the Hadith and the statements of the scholars, and using analogy and basing our understanding on the expert medical advice and scientific advice, we can then come up with an answer as to whether cloning is permitted or not. And because there is no explicit text in the Quran or the Hadith that tells us whether cloning is permitted or not, you will always find differences of views on this issue and any other issue where there is no explicit text. This is where differences of views in Islam comes in. Ibn Taymiyyah, who is otherwise seen as a very conservative, very strict scholar, has added to the higher objectives of Sharia, and he said they include fulfillment of contracts, preservation of ties of kinship, honoring the rights of one's neighbors, love of God, trustworthiness, sincerity. Al-Qaradawi, a contemporary scholar, he said we could add to the list of higher objectives of Sharia social welfare support, freedom, human dignity, and human fraternity. And many others added. For example, we could, this has already been suggested by a number of scholars, environmental protection is a higher objective of Sharia. Looking after the subjugated indigenous communities is a higher objective of Sharia, because fundamentally it links to the centrality of Sharia, and that is the upholding of justice. I'm just going to go through this rather slightly quicker because of time. So application of Sharia in Australia. Quickly, now any discussion concerning the obligation to follow Sharia would be incomplete without understanding the classical and contemporary discussion on what is known as the abodes, or the classifications of the world into Darul Islam and Darul Kufr and Darul Harb, the abode of Islam, the abode of disbelief. And so therefore, an answer to the extent to which Sharia can be applied in a country like Australia depends on how you see Australia. Now, if you see it as Darul Islam, the abode of Islam, or if you see it as the abode of disbelief, or if you define it as the abode of covenant, or the abode of peace, right? Now, I have a whole article on this, and I'll give you the reference at the end, which you most welcome to read. But I won't go into this discussion here because it is just too much. But what I could say is that regardless of what label one gives to Australia, the fact remains that it is a secular democracy, and it is not Islamic in the sense as we understand Islamic. So therefore, to what extent then are Muslims obliged to follow the Sharia in a secular democratic country, right? And principle, we know that Muslims are obliged to follow the dictates of Sharia, whether living in Muslim or non-Muslim countries. And this is agreed upon, but the question is to what extent? And there are, or for example, here's an example as to the application of Sharia wherever you are. So for instance, lying, cheating, fraud are considered haram, unlawful, whether you are living with Muslims or non-Muslims, whether you're in Saudi or Australia. There is consensus on that. Unless you have an extreme view that says dealing with non-Muslims allows you to lie and cheat them. Sadly, we do have some extremist fringe elements who may argue that, but that goes against the consensus. Equally, devotional matters such as the 5-time salah and so forth must be practiced. The idea of practicing Islam or Sharia in a country like Australia falls under a newly coined terminology in jurisprudence known as fiqh al-aqalliyat, or jurisprudence for Muslim minorities. Now, this derives the same rules from the same sources of Sharia, but under this branch of fiqh, a number of legal maxims are utilized to facilitate removing hardship and consideration of public interest for Muslim minorities, like us in Australia. And for example, the juristic principle of hukm al-makan, and that is place-dependent ruling, or hukm al-zaman, time, and customary practices play a very important role in fiqh for Muslim minorities. For this reason, for example, the European Council for Fatwa and Research issued a fatwa allowing Muslim communities in non-Muslim countries, and I take non-Muslim countries broadly, a broad definition of that, and I want to put Australia in that category, although we can discuss this widely. They say they allowed Muslims in countries like Australia to purchase houses with a riba loan or usurious loan from conventional banks, despite clear textual evidence in Sharia that prohibits riba. Why? Because this goes back to the jurisprudence for minorities and time and place and circumstance. In essence, what it is saying, there is some room for interpretation depending on context. And fundamentally, in issues to do with ahwal shakhsiyya or personal status law, Muslims, scholars or jurists agree that minority Muslim communities in countries like Australia are only obliged to follow laws of personal status. This includes, salah and fasting and giving zakah and putting the hijab on and going to the masjid, which we are already doing. But judicial obligations are dropped for minority Muslim communities because they are enforceable through formal sanctions by the courts of justice. Whether you are in a Muslim or non-Muslim country, it is not you who take these laws into your own hand. And so what the Sharia says, things such as the penal code, which is seen as harsh punishment in Islamic law, cannot be enforced, nor should they be enforced, nor should Muslims ask for in their enforcement in a country like Australia, simply because we're not obliged to, and simply because the government of the day does not recognize Sharia, and therefore it is not required in any sense of the term to apply these aspects of Sharia, which are judicial. And these laws belong to a set of rules known to Muslims jurists as al-ahkam al-sultaniyya, principles of government, and are the prerogative of judicial authority. The hudud laws, the penalties that the Quran and Sunnah have prescribed for heinous crimes, which are very few, by the way. And if you were to compare those laws to rabbinical laws, for example, they are minimal in comparison. But the penal code that are harsh penalties for murder, fornication, adultery, rape, and defamation, theft, and the consumption of intoxicants. These laws not only are dropped in a context like Australia, but Sharia itself says you must not even think about those laws because you're not in the right context. But even in Muslim majority countries, the conditions surrounding the applications of the penal code are so strict that some scholars termed these the application of the penal code in Islam as fictional legal laws, meaning it's almost impossible to apply because of the strict conditions that surround them. Clearly, Muslims are not obliged to bring into practice aspects of Sharia that deal with these judicial obligations or those that are the prerogative of the executive powers. And just finally, this is what contemporary scholars like Abdalla bin Bayya, he summarized it beautifully when he says, a Muslim is not obliged to establish Sharia law in civil, financial, or political matters or anything related to the prevailing social order in a non-Muslim country. The reason is that these laws are beyond individuals' capacity, and God does not burden a soul beyond its capacity. A Muslim, however, is obliged to abide by the Sharia rules specific to him or her, such as ibadat, acts of rituals, food, drinks, clothing, and that which relates to matters of marriage and divorce, inheritance, and matters of personal status. So you are most likely practicing much of the Sharia already in Australia. And if Hanson was to know that, I don't know how she would react, because we say, look, being good to a neighbor is practicing Sharia, and being loyal to the law of the nation is practicing Sharia, and being trustworthy is practicing Sharia, and avoiding domestic violence and being kind and compassionate to your wife is practicing Sharia. And so the fear about Sharia and its application is often out of fear-mongering and ignorance or arrogance, and hopefully through discussions like this we can dispel all of that. These slides will be made available, and a list of further readings that I would encourage you to consult. I don't have anything there about readings for the purification of the heart, but I would recommend the translation of Sheikh Hamza Yusuf, his book named Purification of the Heart. That's an excellent book, translation of a poem of one of the great Mauritanian scholars. Just quickly, we do have a minor in Islamic studies, and the topic of Sharia, sacred law in Islam today, is covered fully in a whole course. So if you're interested in more details, absolutely come and join us. And few upcoming webinars, 2nd of July, Islamic law and the prohibition of hoarding, and 16th of July, treasures from the Islamic civilization's golden age. Look, I really apologize that I've taken more than what I expected to, but I hope this was useful. Open it for question and answer. I'm trying to get my chats. might stop sharing so I can see the slides more. Here we go. Thank you.
Thank you, everyone. I think there's a couple of questions there. I think you've answered 2 of them.
Yes.
The last one there from Suwaiba. European Muslim, is it okay for Australian Muslims to purchase a house using banks that charge interest?
All right, so I gave you that fatwa, Suwaiba. Now, again, you'll find differences of views on that particular issue for the very reason that Islam categorically and explicitly prohibits riba or interest. And so the question then is, how do you legalize the purchase, or how do you permit or give a fatwa that says it is permitted to take a loan from a interest-based bank, given that there is explicit unanimous view among Muslim scholars, Sunni, and I must add Shia also, that says riba is haram, interest-based usury is prohibited. And this is where fiqh comes in, Suhaiba. This is where jurisprudence comes in. And Muslim scholars would go back and say, well, has anyone in the past among the classical scholars looked at this? And they say, well, they have. And among the scholars were of the Hanafi school of thought and others. We're talking about giants. We're talking about real classical scholars who said in some circumstances that are deemed darura, dire necessity. But again, there will be different definitions for what is darura. But when there is necessity, and the question is this necessity individual or collective? Then if there is necessity, and if one can demonstrate that there is necessity for purchasing a house from an interest-bearing bank, then the answer is yes, you can, provided certain conditions are met. So what you will find here, there are 2 camps. One that will say, no, you cannot, based on the evidence that they have. But others would say, based on the legal maxims and the higher objectives of Sharia, would say, well, actually you can, provided the following conditions are met. And in fact, there were some prominent contemporary Muslim scholars, the like of Al-Qaradawi, who for 25 years or so declared that it is not allowed to take a loan from an interest-bearing bank, but then changed his view in the last 10 years based on further evidence that he came across, and not based on whims, and not based to satisfy the desire of Muslims living in the West, but he was convinced that there is ample evidence to tell us that there is room and there is possibility for Muslims under certain circumstances to borrow money from interest-bearing banks, right? So I hope that answers your question. Please jump on if you turn your mic on and speak if you would like to, if you feel that I haven't answered it properly or you need more information. I'm happy to provide the fatwa that I have referred to, which stipulates those conditions. Now, just remember one fundamental issue or one fundamental tenet, and that is whenever there is no explicit textual evidence regarding a particular Islamic issue, there is always possibility for interpretation and differences of views. The fact that there are differences of views does not mean there are problems, but rather there is room for negotiation. There is flexibility in the adaptability or the application of Sharia in its broadest term, broadest definition. And that is why the idea of one must understand the context. And that is why it's important to understand that a fatwa, a legal opinion that is based on text only is irrelevant. It is not, it is inaccurate. A fatwa must depend by necessity on text and context. And that is why any scholar who does not understand our context in its details issues a fatwa for us from overseas, we have to be mindful, especially if it relates to our peculiar circumstances. So fatwa is text and context. without which it's pretext. What else is there? Mahr, there is an IG about a newly married couple somewhere in the Mid East that was given by the husband in the form of a hafazan of a surah in lieu of property money mahr that was accepted by the father of the bride. Is this accepted? Right. Yes, as I said, the mahr, as I've said earlier, the beauty here of the Sharia is that it does not stipulate type of the mahr or the amount, if you like. It has left it to the people of the people of every given country. The same is true, by the way, for the dress code. Now, if you go back to the Sharia, it stipulates general, broad, specific guidelines about what constitute Sharia compliant clothing, so to speak, in the form of the hijab or the men's clothing. But never in the Sharia does it stipulate style or color, because you see, Sharia is much more, I would say, comprehensive, but also understanding of human nature. And it says you cannot impose a particular style or color on, say, the Indonesians who love bright colors, right? And that is why the hijab itself manifested itself in different styles and shapes and colors, as long as it fulfills the general guidelines stipulated by the Sharia. Equally with the mahr. If there is agreement, and the condition here is that the bride herself must agree to the form of mahr given, and not the father alone. Now, the father could represent her as the wali, but he should consult with her. And one of my PhD students, Hafsa Khan, wrote a whole PhD thesis on the question of consent, marriage consent. And she looked particularly at the fiqhi jurisprudence and found that fiqhi jurists or jurists from the fiqh school of thought went to the extent of saying that the marriage celebrant, or the imam in this case, must even read the body language of the bride when she is asked for her permission to marry, because he must ascertain and make sure that she is not forced into this marriage. And the same is true in terms of her mahr. The mahr is her right. If they agree on whatever it is, a kangaroo or a koala or whatever it might be, and she's happy with that, then so be it. But we must take into account other teachings of Islam where the Prophet ﷺ said, try to make mahr feasible. Don't complicate it. Now, some very wealthy people would take that as an excuse to be stingy. And that is not acceptable. And that's why the ulama say, wealth is relative. What may seem in your eye to be somebody very wealthy, in the eye of somebody else, they may not be seen to be wealthy. It's relative. And so a wealthy person, Allah says, must give according to their wealth, be generous. And somebody whose financials are constrained we should not impose on them a hefty mahr that is going to break their back.
Assalamu alaikum, Professor.
Wa alaikum assalam wa rahmatullah.
Thank you, Jazakallah, for your presentation. I think it was great. One thing that I really appreciated was when you spoke about if we help our neighbors, that's Sharia. If we are kind to others, that's Sharia. If we do not cheat the system, that's Sharia. I think this is one of the things that are not exactly seen this way about us Muslim people in many different communities. How can we help to, to get this message across to Muslims and non-Muslims out there? Would there be anything that, schools can do, Islamic schools, for example, can do, mosques can do, unis can do, that we can send this across?
Well, absolutely. I think the first and the most important thing for us as a community is to understand, we need to understand to a good extent, what is Sharia and what is fiqh and what are the maqasid of Sharia. Honestly, if you go out to the Muslim community and pick and select any Muslim out there and say, tell me what are the higher objectives of Sharia. How many people do you think would know? We need to educate ourselves first and foremost. So education is necessary. Secondly, we need to be able to have, and if I speak about Islamic schools, I have just done a review of 4 Islamic studies curricula that teaches fiqh or jurisprudence. And these are some of the most commonly used Islamic studies curricula in the English language. And I looked at how they teach fiqh, and this chapter will be published soon in a book that is coming end of this year, inshallah. And the way fiqh is taught is so problematic, it is so basic, it is so regimented, it is so dry, that we actually make Muslims, in this case students, dislike Sharia and dislike fiqh. So we need to educate ourselves, and we need to equip ourselves with the necessary knowledge and skills to be able to teach it in ways that can inspire the next generation to be proud of the Sharia and of fiqh. And once we do that, then we will have a number of people who can present it and write on it in ways that are understood by people who are not Muslim. Until, sadly, if I may say, and allow me to be self-critical here, often we as a community invest in bricks and mortar and not in minds and intellects and the future generation. And Sharia, as much as it is a straightforward topic, it is a complex topic that needs to be understood in more details by us so that we are able to convey it. And this is based on the Arabic proverb, فَاقِدُ الشَّيْءِ لَا يُعْطِيهِ. One who does not possess a thing cannot give it. Right? So, and Islamic schools are wonderful places. They are already doing great job in a lot of areas. Can you imagine with me for a second? We have 61, our last count is 61 Islamic schools in Australia, and a total of about 40, maybe 30 to 40,000 students. Imagine with me if we were able to infuse in these students a deeper, richer understanding of their tradition, what impact that will have down the track. I mean, one of the Islamic studies curricula that I examined that teaches fiqh, why would you want to teach, and excuse me for raising this example here, why would you want to teach the fiqh of breastfeeding to students in grade 10 and 11? Right? Or the penal code when you know it's not being applied. We need to teach them the fiqh of the fiqh, the deeper understanding of jurisprudence and its wider definition and meaning so that so they can use it to become functional in the societies in which they live. I hope that answers. You can see I'm very passionate about this. Sorry.
Hello, brother.
Right.
Thank you, Prof. Do we have any further questions? We've just gone over the time, so just over an hour. This video will be available, and Prof has said that he will make the slides available as well. So please keep your eyes out on our website and Facebook when I start promoting it in the next few days, inshallah. So if you've got, we'll take one last question and then we will let you go for lunch. I think that's just a comment at the end for everyone. Thank you very much.
Yeah, sure. Just that quickly. Thank you, Sister Silma. Absolutely. I mean, you cannot, you see, they both go hand in hand, Sister Selma. Absolutely. We cannot, you see, often when people speak about the teaching of Islam in Islamic schools or anywhere else, and I'm saying teaching of Islam, not Islamic studies, because it's a failure to think that we can teach Islam in Islamic schools only through Islamic studies. We have to move away from this, right? So the teaching of Islam in Islamic schools cannot happen by only fixing the curriculum or the content, which has often been the discussion that if we have an excellent Islamic studies curriculum, then it's all sorted. No, it's not. As you have said, improving the teaching skills of our teachers, 100%. So the pedagogy, the teaching skills, but also, I mean, we have wonderful, wonderful staff in Islamic schools. In an article that I have just finished writing, which also will be published, that looks at student voice in 3 large Islamic schools in Australia, what they have told us about Islamic studies. And one of the positives is that they show reverence and respect for their Islamic studies teachers, right? Because these Islamic studies teachers have a wealth of knowledge, but we need to train them to know how to contextualize it, right? And it is no fault of their own, the fact that they are unable to contextualize it. They have come often from context and educational institutions or systems that taught them what they needed to learn at the time. But how do we help them contextualize what they have learned? This is where teacher training programs, this is where we've been, screaming out and saying Islamic pedagogy is necessary for Islamic schools. And it's not only Islamic studies teachers, as you would agree with me, I know you would agree with me, that need to understand what we are talking about. Everyone working in an Islamic school needs to understand what we are saying here. Because the teaching of Islam must happen all the time in an Islamic school. It must permeate everything, whether it is the man or the lady in the canteen or the bus driver, or the teacher of Islam or the teacher of physics or biology. There has to be a common meta language in Islamic schools, and then a deeper appreciation and understanding of what we mean by Islamic and how are we going to impart it, and must not focus on content only, but turn our attention to investing in our staff. Okay. You know what? I have another Zoom somewhere else, and guy, they must be waiting. But I would love to continue. So maybe
Thank you very much.
take this as an appetizer. So maybe we can have other sessions in the future, inshallah.
Thank you so much, Prof, and everyone else who have contributed and participated. We do have these webinars on a fortnightly basis on various topics. So the next one is coming up on the 2nd of July. And the topic is, I think we ran a slide just now, which I will share with you very quickly. So we've got one scheduled for, sorry, where is it? Are you seeing my screen, I hope?
Yeah, we are.
Upcoming webinar?
Yes.
Yes, so 2nd of July is, the topic is going to be Islamic law on the prohibition of hoarding. That will be presented by Dr. Mahmoud Nathi, who is one of our academic colleagues here. And then the one after that will be on 16th of July. So these are ongoing fortnightly webinars. So please register. Well, I haven't put that up yet. I'll put that up very soon on our website and our Facebook, and we will do marketing. So thank you so much, everyone, for your time. And we will let you all go. Thank you, Prof. We'll let you go to your next Zoom meeting.
Thank you, everybody. Thanks for listening. Assalamu
Thank
alaikum.
you. Alaikum assalam. I will be here just for a few more minutes. So if anybody has any questions, you can unmute yourself and ask me, or put your questions in the chat session there. Happy to discuss. Thank you very much, Rasha. we will get the recording and slides. Alina, the recording will be available on our YouTube channel, and I will also put it on our Facebook in the next coming days, because I'll have to download it and put it up. I will actually stop recording now because we do not want this part recorded.